What was the response to that?
And their response was both professional and responsible. They said that they would do their best to correct the problem. What was unfortunate was they didn't address what was the mechanism for which these materials were moving, which was the evaporation. They dealt with the issue of drift as it happens at time of application. And here's where the law was a bit was confusing. Because when you go in and you read our existing pesticide law, it clearly says that the applicator is responsible to prevent the movement of these chemicals by drift, and that you've got to comply with all these different regulations to prevent drift as defined by law. And the catch is drift is defined by law as being the movement of chemicals at the time of application, not after they're applied. Mm-hmm. After they're applied, the same body of law exempts the movement of these materials by means of volatilization or by means of attachment to dust or other particles blowing in the wind. And that created a problem for us because it indicated, well, legally, the movement of these things wasn't drift, but they were certainly moving. So what do you call them? And in our particular instance, what happened was when the county ag commissioner, who was charged to regulate at the local level what's going on, came to investigate our crop loss and to look to see if there was a violation of the pesticide regulations, found no violation of pesticide regulations. Mm-hmm. At the same time, issued us a stop harvest order because the crops we were growing are not allowed to have any residues on them. That was a little ridiculous because we had stopped harvesting long before. As soon as we had heard, we had stopped.
Right.
But it was counterintuitive that they found nobody responsible or nobody at fault for breaking any regulation.
Right. Larry,
we're causing a repeat of pesticide.
We want to hear more about how this all ended up in the appeals court, but we need to take a break right now to listen to our sponsors. You are listening to Food Integrity Now with our guest, organic farmer Larry Jacobs, and we will be right back. Welcome back to Food Integrity Now. We have as our guest today Larry Jacobs, and Larry is an organic farmer. Larry, what are the names of your farms so people can know and check you out online?
We grow fresh culinary herbs in 2 counties, in San Mateo and Santa Cruz County.
Okay.
And the herbs are labeled Jacobs Farm.
Okay.
That's what we do in California. My wife and I also started 1985. We began organizing, teaching organic farming practices to the small-scale growers at the tip of the Baja California Peninsula, and that's become known as Del Cabo. That's primarily little kind of tiny cherry tomatoes.
Yeah, I'm familiar with those. They're yummy.
The market is Del Cabo. Yeah.
That's exciting.
And they're all over the place today, although we had a bit of a freeze weekend before last. That curtailed the production a little bit.
Yeah, we had that same freeze here. But Larry has been talking about a court case that he was involved with for cross-contamination and just been filling us in on how it all transpired. So you left off with they informed you that you had to stop harvest, which you had already done. And then what happened after that?
Following the county ag commissioner's report, we continued our we continued discussion and talking with our neighbors and with the company that was doing the application, explaining that we were still picking up residues, and this went on for several months into the next year, and with the next year's following year came, and we still were having residue contamination problems after they would do an application. And we'd asked them at this point, we'd asked them to curtail their applications of those materials to use other materials. We faced a difficult decision. We were either going to have to stop farming in that location because we weren't going to be able to grow a crop there that would meet the National Organic Food Act requirement, or we were going to have to move, or we would have to require them to stop using those materials. And the only way we looked like we were going to get them to do that was to go to court, and that's what happened. Began a long, drawn-out court battle that ultimately we prevailed. The case was about the contamination of non-target crops and the movement of pesticides after they were sprayed, and whether an applicator had responsibility for preventing that from happening. And the case boiled down to a fairly simple case about trespass, nuisance, negligence, and whether the applicator was responsible for causing trespass, creating a nuisance, and being negligent in terms of responding to a problem. So
the court ruled in your favor, correct?
And we had a jury trial in the October of 2008, and the jury ruled in our favor, found that the applicator was responsible, and we were awarded damages for the loss of the crop for 2007, not for 2006, but for one of the 2 years. And our understanding was the logic of the jury was that in the prior year, when the incidents first happened, that the applicator wasn't aware of the problem, but in the following year, they clearly were aware of the problem with repeated communications and a letter from our attorney, and that so they held them responsible for the following year's crop losses. That decision was appealed by the chemical company, the company that was doing the application. They appealed to the appellate court, and they raised some interesting legal questions. They primarily raised the question of whether a judge and jury had the right to review and listen to a case that was involving the use of pesticides. They argued that the state of California maintains all jurisdiction over the regulation and the use of pesticides in the state, and that lower government bodies, including the judicial system, do not have the right to hear the case.
Oh, that's interesting. So what happened with that then? How did that get overturned?